Okay, we are back in Senate institutions. Today is Wednesday, May 6th, 2026, and we are still on H 550 and Act relating to gender equity within Vermont's correctional facilities. And we have two folks from GLAAD, and thank you very much for being here on short notice. So we will introduce ourselves and then you can introduce yourselves and we'll ask you, or first, if you have a presentation, feel free to, or we can have questions and answers, and we will certainly have questions. So I'm Wendy Harrison, and I represent the Windham District.
And I'm Rob Plunkett, the Bennington District.
Joe Major, Windsor District.
Or Singles, Essex District.
And our other member, John Benson, is not here right now. So there are five of us. We're looking at this bill that came to us from the House, and we'd like to get your take on it, please.
Great. Thank you so much again for having us, Chair Harrison. My name is Michael Haley. I am a staff attorney at GLBTQ Legal Advocates and Defenders, also known as GLAAD Law, as you mentioned. I'm from New Hampshire, but Vermont really does have a special place in my heart. My husband is from Vermont, and we spent time living together at the Putney School when he was the dean of students there. So very much a fan of the state. We do have just a brief presentation. Sorry, I'm joined by my colleague, Sarah Austin. I don't know, Sarah, you want to introduce yourself?
Sure, yeah. My name's Sarah Austin, and I'm also a staff attorney at GLBTQ Legal Advocates and Defenders, also known as GLAAD or GLAAD Law. And I'm really grateful to be here. So thank you for the invitation.
Great.
We had just sort of a brief overview to start off with. I'm going to just give a little bit of context, and then Sarah, who has been involved in several of our litigation efforts surrounding the rights of incarcerated persons, is going to talk more specifically about what the current legal landscape is. But just to kind of set the table, as I'm sure you're all very well familiar, it's the responsibility of every state to protect the people that it incarcerates. And we are very grateful to Vermont for taking that responsibility so seriously, especially when it comes to vulnerable populations like transgender people. And H 550 is an important recognition, not only of that general responsibility, but of also the heightened responsibility that the state has to shoulder in light of the federal government's ongoing efforts to dehumanize and deny the existence of transgender people and place them at significant risk of harm. So I'm sure you've already heard some testimony from some folks, including survivors of sexual assault. But it's just important to understand that all of the available data consistently shows that transgender people are at a disproportionately high risk of sexual abuse in jails and prisons. That's well known to correctional officials and has been for over a decade. The most recent data that the US government has put forth showed that within a 1-year period, transgender people were at a 10 times greater risk of sexual victimization in prisons, the general level of risk being about 4%, and transgender folks being at around 40%. So it's a really significant risk. And the literature and reports from non-governmental sources have estimated that transgender people's lifetime sexual assault rates in prisons repeatedly clocks in around 50%. So it is really a significant danger that they face. And the Prison Rape Elimination Act, PREA, was designed really with one idea in mind, that like even a single sexual assault, a single rape in prison is unacceptable. There's this sort of a zero tolerance idea here. And it also is an acknowledgement that every individual is made up of a multitude of different characteristics that can put them at a greater or lesser risk for sexual assault. And so what we're talking about here, and the policy that Vermont currently has in place and what H 550 proposes, is really just acknowledgement of that fact that among everybody's constellation of different attributes that they have, there are things that make them more at risk and less at risk. And we know that being transgender is one of the factors that makes people at greater risk. And so the PREA regulations that are in effect now are just an acknowledgement that and a requirement of an individualized assessment, looking at and each individual's characteristics, among them whether they are transgender, but many other characteristics as well, to determine what is going to be the placement and the procedures to protect them the best and to protect everybody in the prison, including staff and other inmates, against sexual assault. So that includes assessments of health and safety, of security concerns from particular housing, bedding situations, programming assignments, showering facilities. It's really a case-by-case assessment of whether an individual should be placed in a men's facility or a women's facility. And yeah, and sometimes for transgender women, the only safe housing option for them is in a women's facility. And that placement is workable and has been workable in Vermont for a long time now. When that does not happen, the predictable result is that there is recurring sexual assault and rape and oftentimes long-term protective custody, which is effectively solitary confinement that has severe mental health consequences. And many people who are incarcerated experience both of those things. So the types of decisions, like making the decisions about where someone is housed, who they are housed with, what access they have to what facilities, those are the strongest tools that the department has to determine what is going to protect individuals and the population at large from sexual assault. And reducing sexual assault overall for individuals also, makes the entire prison a safer place. There are a number of other provisions in the PREA regulations that are in effect now, including a twice yearly assessment of health and safety risks to transgender incarcerated people in their current placements, giving the opportunity to have separate shower opportunities rather than being in congregate shower facilities, requiring staff training for effective and respectful communication, and incident reviews to determine whether assaults are motivated by a victim's actual perceived LGBTQ status. And these, like everything else, are not like a singling out and a special treatment of transgender people. It is an acknowledgement that among all the factors that might cause somebody to be more or less at risk of sexual assault, being transgender is one of those things. And so taking that factor seriously in the same way that you would take into account any other factor that might increase or decrease someone's risk of sexual assault. Sarah, like I mentioned, has been working really carefully on a number of issues surrounding how the current administration is treating transgender folks in federal prisons. And so she's going to kind of talk about the current landscape and what's going on there.
Yeah, thank you so much, Michael, for providing that great summary of the legal landscape and the backdrop of the PREA regulations, which really informs this discussion. You all might be wondering, because Michael said multiple times the PREA regulations that are in effect now, okay, so why do we need this bill also? And the answer is that the federal government is taking sustained effort to try to roll back those carefully crafted PREA protections that are intended to protect really everyone from sexual abuse, but especially transgender incarcerated people, given their particular risks of sexual violence in prison. So the first example of this is last year, on day one of the current administration, the president issued an executive order that directed the Federal Bureau of Prisons to house all transgender women in men's facilities, which would have required transfer of the very small number of transgender women who had been placed in women's facilities from women's to men's facilities. So this was a categorical directive. It didn't leave any room for the type of individualized assessment that the PREA regulations require or that H550 contemplates. It was directly contrary to the binding regulations, and it was immediately challenged and enjoined for the transgender women who were already in women's facilities. So they were kept in women's facilities, and that litigation is ongoing. And then in December of 2025, the United States Department of Justice issued a memo internally saying that state and federal correctional facilities nationwide would, quote, no longer be held to, unquote, the PREA regulations, and that facilities should not follow the PREA regulations to the extent that they protect transgender people and intersex people and gender nonconforming people. And in addition to that, the federal government has also taken steps to begin the process to amend the PREA regulations that exist today. So they've issued this directive to facilities not to follow those regulations, and they're taking steps to actually undo them. So we expect that they will rescind the regulations protecting transgender people, sort of consistent with what they said in their memo. But there may be other changes too that affect all incarcerated people and regardless of gender. And we really don't know what those might be. So what does state law have to do with this? I think the first and most obvious point to make is that if the PREA regulations are repealed or changed, then incarcerated people will only be protected to the extent it's provided for in state law. So even if Vermont, which you do, has PREA compliant policies at the department level, those are not binding in the same way that a state statute is, and they're not binding in the same way that federal regulations are. So if those regulations go away, there's kind of a vacuum, and that might cause a lot of confusion for staff on the ground and also for incarcerated people. And it could also lead to sort of whiplash changes in policies with every change in administration at the state level and the federal level. And consistency is really key in protecting prisoners from sexual violence because, you know, the conditions of confinement sort of rely on stable forward movement and forward progress in terms of, you know, the level of protections that are provided. Otherwise, it would be really hard for those protections to be effective if they're sort of there one day and gone the next. And I'll just say the federal government's actions to undo the PREA regulations have had on the ground impact. And we've heard reports at GLADlaw over the past several months of correctional officers in the region revoking PREA-related housing and search accommodations for transgender people, and at times even suggesting to transgender people who are incarcerated that PREA no longer exists, or those accommodations are no longer available, or PREA no longer protects them because they are transgender. So even when great policies are in place, the federal government's sustained attack on the policies has generated a lot of confusion and in some cases a loss of legal rights for individuals. And so that's why it's so important to make it clear under binding state law and not just policy that Vermont will continue to comply with its own longstanding policies and longstanding PREA regulations and take steps to prevent sexual violence against transgender incarcerated people by continuing to do these careful individualized assessments and implementation of other protections that are contemplated in H550. You know, it's really important to provide clear and consistent guidance to correctional officials on the ground, and important to ensure that Vermont establishes a floor of protection that's going to stay constant even as federal administrations change. And then, you know, nobody likes to talk about the threat of litigation or legal liability, but I will just mention that not having these protections in place would leave the department vulnerable to liability under the Eighth Amendment and possibly other constitutional laws. Courts around the country have repeatedly recognized the unique vulnerability of transgender women in men's correctional facilities, and courts have found Eighth Amendment violations for officers' failure to protect transgender women from prison rape. Courts have also found that categorical housing policies that automatically place transgender women in men's prisons can result in constitutional violations, both under the Equal Protection Clause and also under the Eighth Amendment of the US Constitution. So without a binding state law requiring these kind of individualized assessments, sort of steering away from categorical rules and towards protection of the individual and preservation of the institutional security. I mean, that's a huge part of the equation as well. And we wouldn't suggest that drops out of the picture, but that, you know, careful assessment of the facts on the ground from the individual's perspective and the institution's perspective remains the gold standard. And without sort of codifying that into the state law, DOC could become vulnerable based on changes in administration to, you know, changes in policy that would expose the department to legal liability and lawsuits. So that's sort of my take on how H550 lands in this particular moment when these longstanding protections are in flux and have been called into doubt by unlawful federal government actions. So I think that's all I have to say, and we're happy to answer any questions that you have, and if we don't know, we'll follow up.
Thank you. That's very helpful and very comprehensive. All right, do we have questions?
I just have a request. Ms. Austin, you had mentioned that there were cases finding Eighth Amendment violations regarding treatment of transgender. Can you share those with us, or at least an exemplar? I'm a lawyer, so I want to read the case, so I'm really into it. But and I guess for both of you, I do have a question. I think you kind of touched on everything that I had been thinking about this, but just in terms of H550 itself, have you both read over the language of it? Okay,
Yes.
so and this is a question. I don't know if this is the case, but it seems like we've got a couple of things that we're doing in 550, mainly a couple of things. One is codifying PRIA as it stands right now, but then also codifying DOC policy also as it stands right now. But it seems like the DOC policy is implementing the PRIA standards. And that's my question. Am I correct about that? That what we're looking at is a DOC policy that's implementing the PRIA standards.
Yes, I think that's overall accurate. I see the sort of text of the legislation apart from the adoption of the PRIA standards as kind of putting meat on the bones of what do these individualized assessments look like and what's the process by which we're going to do them. So I think you're right about that. There are a couple things in the PRIA standards themselves that I would just highlight as additional layers of protection. Like, for example, the PRIA standards categorically require that transgender individuals should be given the opportunity to shower separately from other people, regardless of what facility they're placed in. And that's to protect everyone's safety. So that is like an example of something where, you know, the PRIA regulation itself should be adopted and codified in addition to the implementing language about individualized assessments that appears in the text of H550.
Gotcha. And in your reading of H550, would it prevent DOC? So DOC's policies right now, it's not rulemaking, so they don't have to go through the APA. It's just they go through their own policy making process. But do you see H550 as in any way preventing DOC from adopting a policy that enhances protections beyond what would be in statute?
That's a great question, and I haven't read it with that in mind.
Okay.
So I'd want to review it and get back to you on that.
Yeah, that was an issue that was raised by the commissioner. I think generally we probably don't want to prohibit DOC from having enhanced protections.
Yes.
Thank you, Madam Chair. You mentioned individualized assessments. And I think what's important is those assessments be spelled out, as well as what's the determinant. I think that's incredibly important in figuring this out.
Yes, I completely agree. And I think something really powerful in the legislation is the requirement that the reasons for the decision are documented, so that, you know, everyone from the correction side can learn from going through this process over and over again for individuals who are affected by it, and also so that individuals who are affected by it can understand what's the basis of this determination, and if anything, if there are any steps I need to take as an individual to support my request, like I might take those, for example. So I think that's really important. And I want to emphasize again, like, the types of factors that could be considered as part of an individualized assessment are really wide-ranging, and they consider the individual's health and safety, and they also consider management and security concerns. That's what PRIA requires, and that's how I read H550 as well. And this could look at all kinds of factors. It can look at the person's age. It can look at their criminal record, their disciplinary record, their behavior while incarcerated, if they've already been incarcerated, their physical and mental health status, their current functioning in their current institution, their education level, any gang involvement, any risks to other incarcerated people that might be posed by different placements, any chance that they have a propensity for harming others in any way, their vulnerability to violence by others, their vulnerability to sexual abuse by others, and their ability to function in the general population of the target facility, you know, the facility being considered. So it's really a wide-ranging inquiry, and we would expect to see different outcomes for different individuals because everyone is different. Everyone has their own risk profile. and that might require different decisions depending on individual circumstances.
And to kind of piggyback on that last thing, and that even the word in transitioning is a period of time. And at what point, if a person is transitioning, do they go from a male to a female or a female to a male? Where is that? Is that a physical? Is that a mental? Is that it's so I think that is important too. And then once and if that transition is happening, then what? If they do they go from one facility to another? Those types of things. The reason I'm being very precise on this is if this is going to come to fruition, these are the questions, and rightfully so, that are going to be asked. And also, just for my own education, I would want to know what that process is. Does that make sense?
Yeah, I think these are great questions, and I think I understand them. I mean, my first reaction is, and in my understanding, you can correct me if I'm wrong, is that H550 is really codifying Vermont's current practices. And so to the extent you're wondering, how does this process work? I think it's been in place before, and has been for years. So DOC would be the best entity to ask. I can't speak to what happens specifically in the department in Vermont, but I think there are answers to your questions. I also think there are no bright lines here. Like I said, any assessment would have to consider all the factors you mentioned and all the other relevant factors. So I don't think there is a moment in time where, any transgender person who's at X stage of their transition gets transferred to a different sex facility. I think it really depends on individual circumstances. There are a lot of people who are transgender who have transitioned before ever being incarcerated. Some transitioned when they were young, some transitioned and got surgery, including genital surgery, and are physically indistinguishable from any other person of that gender. And so, it's going to look different for every person. Not every person is going to be transitioning while incarcerated. So I think DOC is the best, will have the best answers to your questions, but it really does depend on a holistic view of the whole person and also what the institution needs to function and run safely and smoothly.
Okay, and I just think it's important that we try to look at all scenarios and to cover that for everyone involved, for the inmate, for the staff. It is. I think that's just very important that we know, and for the person assessing those things as well. So I appreciate your answer.
And I think just to sort of further analogize some of the things Sarah was talking about as risk factors, there are things like age, right, or education or mental health status. And those are all things that could change over the course of time that somebody is incarcerated. And there's no point where you say, like as soon as someone goes from being 45 to 46, they need to go to a different place, or as soon as somebody gets a GED, then they need to go to a different unit. But these are all things that are risk factors and might inform a prison official's decision as to where is the best housing location, just like where somebody might be on their transition. And that's why the individual assessment that takes all of these various factors into account is so important and so useful as a tool to achieving the overall goal of reducing sexual assault in prisons.
Thank you. I know I agree with the individual assessment. I want to make sure that when we do the assessments are we doing apples to oranges, or are we doing apples to apples? And I think that's, and I understand it's not as simple as that. I mean, like it to be as simple as that. But if we can get as much clarity as we possibly can, that's important in codifying this legislation.
Okay, all right. So are you good?
Yeah, I'm sorry, yeah.
No, no,
yeah,
no,
yeah.
that's okay.
I'm good.
Senator Engels, do you have a question? So I have two questions. Are there any edits that you would suggest to this language?
Michael, did you have a thought on that? I don't have it in front of me.
So there's one paragraph on page 15 of 21 up towards the top. I'm looking at the version that I found, the most recent version I saw online that said like the official version that came from the House. And there's a paragraph 2 that says the department shall make its classification and housing placement determinations on an objective basis. And we just weren't 100% sure what that meant. Part of the PREA assessment is necessarily like a predictive assessment, right? Like looking at all these factors and what might lead someone to be more or less likely to suffer sexual assault. And if it's the intent of that paragraph to be saying, but if the point of saying objective is to say, like without regard for personal biases around transgender status, then that's great. We weren't 100% sure on what that paragraph itself meant, and thought that if this is existing already in DOC policy, it might be worth checking with the DOC to see what their reading of that is, and to potentially clarify that language.
Thank you. Did you say page 15? Because I think that might have been a previous.
Page 8.
Oh.
Oh, I'm sorry. Page 8.
It's on page 50. Oh, sorry.
Well,
Sorry, we're looking at draft number 1.1, I believe is.
Well,
passed.
I'm looking at this passed by the House. That's 14 pages total.
Oh, okay. I think I have one that has several pages of like crossed out in front of it that brings it up higher. I may have the wrong version.
Or it may just be a different version of the same bill, but if the language is in the striking, I mean, you would know.
No, yeah, it's let me see what it actually is. This would be.
You have the official version. That's what it was.
Okay, yeah, it would be 28 VSA section 701C, and then parentheses D2.
Are you able to find that?
I was able to find it on. Let me see if I can get the.
Which draft did you read? Yeah, 1.1.
So that's our draft 1.1.
On our web page, that on half by house, it's on page 8, line 2,
Now I'm on 1.1 of ours. So
and that's on page 8. Look further down.
okay, great.
Each 4, line 4.
Okay, so you have the department shall make its classification and housing placement determinations on an objective basis. Is that?
Yes, that was just the language. We weren't quite sure what it was intending to say. And like I said, if the purpose of that is just to say, like without regard for the individual officer's personal convictions about sex and gender, that's fine. It just wasn't clear from that language that was what that was intended to mean. If it was meant to mean that the department could not make these predictive judgments about who is more or less likely to suffer from sexual assault, then that would sort of defeat the purpose of PREA.
Interesting.
I think Haley has an answer.
Yeah, Haley, did you want to comment on that?
Yeah, I'm happy to jump in here. And for the record, Haley Summer, Director of Communications for the Department of Corrections. This bill went through many kind of lengthy drafts, and the committee was very intentional about the language that they placed. So I appreciate the point that you brought up, Michael. To the best of my recollection, the reason why that specific phrase was put in there was to make sure that the decisions did not take into account anyone's personal bias. So hopefully that's in alignment with best practice and with what you were saying earlier.
Yeah, that's good to know.
Yeah.
Thank you.
Okay. Great, thanks for saying that. So then my other question, Michael, you said my notes are workable in Vermont for a long time now, was what I heard you say, if I am interpreting it right. And I'm just wondering how you came to that conclusion.
Well, we do hear so much from people when things go wrong. And we do have a lot of partners in network in Vermont who reach out to us when we hear of issues. And we, to your credit, have not heard significant issues in Vermont around these particular concerns. Of course, I don't have like eyes inside the department and don't know exactly what's going on there, but it is unusual in today's environment to not hear of problems. And to Vermont's credit, like I said, we have not been hearing of issues. So that was mostly what I was basing it off of. But again, as Sarah mentioned, this is codifying regulations that have been in effect for quite some time now, and so passing H550 amounts to like continuing what's already in place rather than requiring new changes to continue on the good work that's been happening.
Okay, that is very helpful. Thank you. All right, I think there's no more questions. I think we are good.
Great.
This has been super helpful, and thank you very much for your time. And we are going to, I'm sorry, are you?
Oh no, I was going to say thank you so much for having us, and we can get you a list of some of the Eighth Amendment cases that you requested.
Oh, that'd be perfect.
Thank you very much.
All right, thank you so much.
Thank you so much.
Thank you.
Thanks. All right, and we are adjourned.